Law Maxims, Doctrines and Principles. Part 2. By Amicus Curiae. Number 41. Doctrine of Political Question. What it means. Certain issues are beyond judicial review. Courts avoid interfering in political matters. This preserves separation of powers. That's Doctrine of Political Question. Number 42. Doctrine of Nullum Crimen Nulla Poena. What it means. No crime without law punishing it. Crimes must be defined by statute. This prevents ex post facto punishment. That's Doctrine of Nullum Crimen Nulla Poena. Number 43. Doctrine of Retroactivity of Penal Laws Favoring Accused. What it means. Favorable penal laws apply retroactively. Protects accused from harsher penalties. This ensures fairness in criminal justice. That's Doctrine of Retroactivity of Penal Laws Favoring Accused. Number 44. Doctrine of Double Jeopardy. What it means. No person shall be twice put in jeopardy. Prevents repeated trials for the same offense. This ensures finality in criminal cases. That's Doctrine of Double Jeopardy. Number 45. Doctrine of Continuing Presumption of Innocence. What it means. Accused remains innocent until proven guilty. Protects liberty during trial. This ensures fairness in criminal justice. That's Doctrine of Continuing Presumption of Innocence. Number 46. Doctrine of Judicial Efficiency in Criminal Cases. What it means. Courts must avoid unnecessary delay. Promotes speedy resolution of cases. This ensures justice is not denied by delay. That's Doctrine of Judicial Efficiency in Criminal Cases. Number 47. Doctrine of Finality of Acquittal. What it means. Acquittals are final and unappealable. Protects accused from repeated prosecution. This strengthens double jeopardy protection. That's Doctrine of Finality of Acquittal. Number 48. Doctrine of Continuing Offense in Illegal Possession. What it means. Illegal possession is a continuing crime. Liability persists until possession ends. This affects jurisdiction and prosecution. That's Doctrine of Continuing Offense in Illegal Possession. Number 49. Doctrine of Conspiracy in Treason. What it means. Agreement to commit treason makes all liable. Conspirators share liability for treason. This emphasizes collective responsibility in crimes against the state. That's Doctrine of Conspiracy in Treason. Number 50. Doctrine of Political Crimes Absorption. What it means. Political crimes absorb common crimes. Prevents multiple charges for acts committed in rebellion. This protects political offenders. That's Doctrine of Political Crimes Absorption. Number 51. Lex prospicit, non-respicit. What it means. The law looks forward, not backward. Laws are presumed prospective unless retroactivity is expressly stated. This protects vested rights and ensures fairness. That's lex prospicit, non-respicit. Number 52. Lex specialis derogat generali. What it means. Special law prevails over general law. Specific provisions override general ones when both apply. This ensures that specialized statutes are given priority. That's lex specialis derogat generali. Number 53. Lex posterior derogat priori. What it means. Later law repeals earlier law. Newer laws supersede older conflicting ones. This maintains coherence in the legal system. That's lex posterior derogat priori. Number 54. Lex non cogit ad impossibilia. What it means. The law does not compel the impossible. Courts do not require impossible compliance. This principle prevents unjust outcomes. That's lex non cogit ad impossibilia. Number 55. Expressio unius est exclusio alterius. What it means. The express mention of one excludes others. Enumerated items exclude those not listed. This limits interpretation to what lawmakers intended. That's Expressio unius est exclusio alterius. Number 56. Ejusdem generis. What it means. Of the same kind. General words are limited by specific enumeration. This prevents overly broad application of statutes. That's Ejusdem generis. Number 57. Doctrine of Necessary Implication. What it means. What is implied is part of the law. Courts read implied powers into statutes. This ensures laws are workable and effective. That's Doctrine of Necessary Implication. Number 58. Doctrine of Casus omissus. What it means. Omitted cases are not supplied by courts. Courts cannot add what the legislature omitted. This respects legislative intent. That's Doctrine of Casus omissus. Number 59. Doctrine of Contemporanea expositio. What it means. Early interpretation is persuasive. Long-standing administrative interpretation carries weight. This promotes stability in statutory meaning. That's Doctrine of Contemporanea expositio. Number 60. Doctrine of Prospective Application. What it means. Laws apply prospectively unless otherwise stated. Protects vested rights from retroactive impairment. This ensures predictability in law. That's doctrine of prospective application. Number 61. Doctrine of strict construction of penal laws. What it means. Penal laws are strictly construed against the state. Ambiguities favor the accused. This protects liberty from overreach. That's doctrine of strict construction of penal laws. Number 62. Doctrine of liberal construction of social legislation. What it means. Social laws are liberally construed in favor of beneficiaries. Protects laborers, tenants, and marginalized groups. This fulfills the social justice mandate. That's doctrine of liberal construction of social legislation. Number 63. Doctrine of plain meaning rule. What it means. Words must be given their ordinary meaning. Courts apply the literal text of statutes. This avoids judicial legislation. That's doctrine of plain meaning rule. Number 64. Doctrine of legislative intent. What it means. Statutes must be interpreted according to legislative intent. Courts look at history and purpose of laws. This ensures faithful application. That's doctrine of legislative intent. Number 65. Doctrine of harmonization. What it means. Statutes must be read together to avoid conflict. Courts reconcile provisions to give effect to all. This promotes coherence in law. That's doctrine of harmonization. Number 66. Doctrine of repeals by implication. What it means. Repeals are not favored unless clear. Courts avoid implied repeals. This preserves stability in statutes. That's doctrine of repeals by implication. Number 67. Doctrine of in pari materia. What it means. Statutes on the same subject are construed together. Related laws are read as one system. This ensures consistency. That's doctrine of in pari materia. Number 68. Doctrine of beneficent construction. What it means. Laws promoting welfare must be liberally construed. Courts interpret laws to advance social good. This fulfills constitutional policy. That's doctrine of beneficent construction. Number 69. Doctrine of strictissimi juris. What it means. Penal statutes are construed strictly. Protects accused from expansive interpretation. This ensures fairness in criminal law. That's doctrine of strictissimi juris. Number 70. Doctrine of legislative supremacy. What it means. Legislature is supreme in lawmaking. Courts cannot substitute their judgment. This respects separation of powers. That's doctrine of legislative supremacy. Number 71. Doctrine of constitutional supremacy. What it means. Constitution prevails over statutes. Any law inconsistent with the Constitution is void. This ensures fidelity to the fundamental law. That's doctrine of constitutional supremacy. Number 72. Doctrine of presumption of constitutionality. What it means. Laws are presumed valid. Courts uphold statutes unless clearly unconstitutional. This respects legislative authority. That's doctrine of presumption of constitutionality. Number 73. Doctrine of severability. What it means. Invalid parts of a law may be severed. Courts preserve valid portions of statutes. This avoids wholesale invalidation. That's doctrine of severability. Number 74. Doctrine of Ejusdem generis, extended. What it means. General terms are restricted by specific ones. Prevents unintended expansion of laws. This ensures narrow application. That's doctrine of Ejusdem generis, extended. Number 75. Doctrine of Expressio facit cessare tacitum. What it means. Express mention excludes implied ones. Courts respect explicit statutory language. This prevents judicial overreach. That's doctrine of Expressio facit cessare tacitum. Number 76. Audi alterum partem. What it means. Hear the other side. No one should be condemned unheard. This ensures due process and fairness in administrative and judicial proceedings. That's Audi alterum partem. Number 77. Doctrine of separation of powers. What it means. Government powers are divided among branches. Prevents concentration of authority. This ensures checks and balances in governance. That's doctrine of separation of powers. Number 78. Doctrine of checks and balances. What it means. Each branch restrains the others. Prevents abuse of power. This maintains equilibrium in government. That's doctrine of checks and balances. Number 79. Doctrine of constitutional supremacy. What it means. Constitution prevails over statutes. Any law inconsistent with the Constitution is void. This ensures fidelity to the fundamental law. That's doctrine of constitutional supremacy. Number 80. Doctrine of presumption of constitutionality. What it means. Laws are presumed valid. Courts uphold statutes unless clearly unconstitutional. This respects legislative authority. That's doctrine of presumption of constitutionality. Like and subscribe to Amicus Curious for more law school and bar exam related videos and shorts.